Good morning, my Lord. My Lord, I appear together with my learned friend Julia Lois for the appellant, and my learned friend Rowan Pennington Benton has been instructed by Harkus Sinclair, appearing for the respondent. My Lords, this is an appeal against the judgment of the Civil Court of Appeal, dated the 13th of May 2011, which approved the trial court judgment of the 13th of July 2009. Now, my Lords, we have given a written case.
Yes, but we've read that very carefully, obviously.
I'm obliged. And I don't intend to go through in any greater details, save that I want to highlight a few issues. But from the outset, my Lords, I would like to just state that we feel that on issue A, which is basically how the proposed amendment were dealt with, the motion for amending the defense of the appellant, if that were to succeed, then the most practical way to deal with this case would be to send the case back. And we don't propose that your lordships actually do the evaluation and examine the proposals.
Well, I'm very pleased to hear that, because we wouldn't have done that in any event.
We understood that. So this is first of all, we just get this part out of the way. And the second thing, my Lords, is that my learned friend has raised a preliminary point based on the issue of that the appellant didn't seek leave from the trial judge before appealing. So maybe perhaps this is more convenient for me to address that point first.
Yes, but I think we'll hear the substantive appeal to bene esse, so you can proceed in whichever order you wish.
Yes, I'll just probably, it's best for me to get this out of the way. And there's not much that I wish to say about this, simply because this is not part of the written case. The first thing is that the appeal was heard by the Court of Appeal, obviously, and it is our respectful submission that the fact that the Court of Civil Appeal, heard the appeal, and that the respondent never raised the issue during appeal, it is impliedly akin to waiving the need for seeking leave before.
Well, can it be waived? I mean, if you need leave to appeal or notice of appeal, I mean, is it open to your opponent to say, well, it doesn't matter that hasn't been done?
Well, probably the use of the word waived is not correct, but what is probably more important, my Lords, is that if an application would have been made to the learned judge and it would have been refused, then obviously the Court of Civil Appeal has jurisdiction to actually grant or refuse such leave. The fact that they heard the appeal, and this issue has been highlighted during the proceeding of leave stage, and the Court of Civil Appeal did ask the question, well, how relevant it is at this stage. And I think I will rest my argument just on this, that it is no longer.
They impliedly gave you leave by...
This is it. I think this would be the more proper term to use rather than waiving.
Right. Well, then let's move on to this.
Yes. Now, my Lord, one of the points that I wish to address, apart from the written case, is that neither the trial court nor the Court of Civil Appeal actually addressed the Rule 17 of the Supreme Court Rules of Mauritius, which actually governs the legal principles. And if I may, at this stage, take your lordships to the bundle of authorities, which is volume 4, tab B.
I haven't got a bundle.
And that would be...
Is the one set out in your case, or is it?
It is set out in the case, and it's also in the authority. Yeah. It is set out in the written case.
Yes.
there may be there is a problem with the numbering between the electronic bundle and the physical hard copy. So I hope it will not be a problem to actually refer. So I'm referring to tab B on the hard copy, and at page 10, and in the electronic...
Which rule are you referring to?
17, rule 17. That would probably be at electronic page 284. Is it? 284, my lord.
Yeah, thank you.
And if I may read,
well, we've read this already.
Right.
In your case.
It is, my lord. The point is, inherent in 17.1, there is a need in our respectful submission for the trial judge to actually examine the proposed amendments and to be able to determine, to be able to answer the question, which is, does the amendment, the proposed amendment, determine the real issue in controversy between the parties? This, my lord, this is central to this appeal, as no such opportunity was given in the course of the hearing. And
well, when you say no opportunity was given, one of the slightly surprising aspects of this case is no opportunity appears to have been taken to press the judge to hear the reasons for the amendment and the merits of the application to have it permitted.
Well, what happened, my lord, is that if one looks at the record, counsel seems to say, I mean, I was the one who appeared.
Yes.
I insist on the motion. And what that means is that I am asking for arguments on both sides. That's what I mean, that I'm insisting on my motion. So whatever comments
The Court of
have been
Appeal
made,
seem to be influenced by the circumstance that when the trial judge indicated that he was refusing it, there was no application made to him to hear submissions.
no, in fact, there wasn't. And this is, as I explained, when I said I insist, this is what precisely I meant. But if one looks at if your lordships look at the records, basically there was no time. It was done at the same breath. So the ruling was already given before anyone could understand what was happening, at least before we could understand what was happening.
Yes, but it's not an uncommon experience for counsel to say, well, my lord, before you confirm that, may I be heard on the reasons that the amendment is sought.
Yes, indeed. I am not going to stand here, my lords, and say that there was no responsibility on my part.
No.
Indeed.
No, well, I mean, nothing that I say should be taken as implying any fault on your part, but we have to, I think, do we not, accept the findings of the Court of Appeal as to what transpired before the trial judge. I mean, we can't be a reviewing court in the sense of investigating the facts again, can we?
No, it is not about investigating the facts, but what we submit, my lord, is that whatever takes place between the parties, the court has a duty in, especially when dealing with an application as application to amend under Rule 17, is that there is a duty to actually look at the proposals, look at any documents which has been proposed, and then come to a conclusion. This seemed not to have taken place, and this is the central issue. That's why I said in the beginning that it is this part which basically snowballs in everything that happened after that.
Well, I think it depends on what is meant by the real question and controversy between the parties. And the real question and controversy between the parties, in this case, might be thought to be the lateness of the application, the transformation of the defence, and the lack of any notice of any significance to the plaintiff.
Yeah, it is true that the proposed amendment came rather late in the day, although it came before the trial. But as in my written case, I've set out that it is not uncommon, if it is indeed to determine the issue between the controversy between the parties, whether what is being proposed actually does determine the issues between the parties. Now, I do not propose to go into detail and examine the documents or the proposed amendments, but very briefly, my lord, is that on the one hand, the plaintiff is saying he was a builder, and we have in the amendment and in the document showing quite the contrary. Now, it is from what has been produced as part of the proposed amendments, one can see that the appellant at that stage had a serious defense, a bona fide and a serious defense.
Well, the only problem was that it went directly counter to his former pleadings.
Yes, it did. It did indeed. And he explains that. He explains that he found the box with the documents late and the advanced age of the appellant. And all these are consideration, but what is probably important is before we even go there, is that the exercise was not done by the trial court. And it is, with all due respect, irrelevant at this stage. What is relevant in our respectful submission is what was the exercise that ought to have been done by the trial court. And the exercise is to actually look. There is nothing to suggest, and indeed the trial judge never even looked at the proposals and didn't even look at the documents.
How do we know that? I mean,
because once the documents were submitted from the record, there is nothing to suggest that he did. It all happened just...
That wouldn't be necessarily recorded, would it?
No, it wouldn't be recorded. But
And he had been told that the proposed offence completely transformed the pleadings of the
that's right.
appellant.
And he's also been told that now there is a counterclaim which didn't exist in the original plea.
Yeah.
well, I mean, were the papers filed before, or are they presented to the court?
The papers are only filed when the case is called.
So on the 30th?
The papers were served, yes, the papers were served on the 9th.
On the other side?
Yes.
But the court would only get them on the 30th?
It will only get there on the... It would have been filed in the registry, but the court would not have access to that.
Right.
So that is the issue about Rule 17, my lords.
Yes.
And I would perhaps now move into the case of Labrouche and Fay, which is a 2012 case, the first volume of the law report, which has been relied by my learned friend for the respondent. My lord, without necessarily going into details, but the essence in this judgment is that it is agreed and established that a hearing is vital to ensure that there has been fairness in proceedings, and both in the case of Labrouche does exactly that. And if I may, and I think Labrouche also deals with the issue of when counsel doesn't actually raise or press into his motion and makes it clear that there is he wishes to submit in law. I think Labrouche also says that, well, if I may refer your lordships to paragraph 31 of Labrouche, which is in volume 4.
Yes.
And the electronic page is 362, I think.
Yes, it is.
Yes. If I may read paragraph 31, my lord.
Yes.
It said, of course, it is almost always possible, with the benefit of the transcript of the hearing and a careful analysis of what precisely might have been conveyed by certain words, to suggest, with wisdom of hindsight, something which an advocate could or even should have said. However, it is important to adopt a realistic approach to what is to be expected of an advocate, or indeed a judge or a witness, in the heat of the moment in court. Further, as Lord Justice Reimer pointed out in argument, what one cannot get from a transcript is the tone of voice, facial expression, or even gestures of a speaker. This is in line of your question earlier, my Lord, that yes, probably I did not press on the need to submit, but this is where the court's responsibility also comes into play, and for fairness, and with the requirements set out under Rule 17, I submit that indeed a hearing ought to have been given. Now, and LaRouche has also been confirmed in Dunbar, which is on, if you look at the hard copy, if your Lordship look at the hard copy, it's the last tab, which is J. And if I may just read from the case of Dunbar and Dorcas Holdings Limited, which is a 2013 case reported in the EWCA. I just perhaps refer your Lordships to paragraph 28, but which is the last page of the judgment. That's where I'm going to refer, which is page 93 in the hard copy.
Yes, I have.
And 4 words after the, at the end of the sentence, and what I want to refer here, my lords, is as the LaRouche case makes clear, the denial to a party of any opportunity to make submissions in support of its case is a fundamental denial of procedural justice in its own right, regardless of the consequences.
Well, I think that probably isn't in controversy, but the difficulty, I think, here, Mr. Trelawney, is that the Court of Appeal has found that the trial judge did not deny the defendant the opportunity to make submissions.
But this is where we say, with all due respect, my lords, is that this is where the Court of Appeal is wrong.
Yes, can we second-guess the Court of Appeal on what was essentially a finding of fact?
Well, I think it's more based, my lord, on what is the legal principle which governs amendments. The Court of Appeal suggests that, yes, there has been no procedural unfairness, but with all due respect, there has been no opportunity offered. Okay, there has been, the appellant didn't press on submission, but faced with what we have, there has been no opportunity given to submit. And this is central to what happened next, because dealing just very, very briefly.
So your submission resolves to this proposition, does it?
Yes.
That the trial judge should, of his own initiative, have offered you the opportunity to make submissions.
Well, I say it is probably not a question of his own initiative. I think it's a question of right.
Right. Well, however one puts it, the trial judge should have given you the opportunity to make submissions.
It is.
Yeah.
This is indeed our submission.
Yeah.
And
it's not a question of whether he denied you the opportunity. He actually should have positively given you the opportunity.
yes, probably denied is rather strong in that sense. Yes, but the consequence, my lord, is that if one looks, without going into much details, if one looks at the proposed amendments.
Are we leaving this case? Because we ought to have a look at the second half of the paragraph 28 as well as the first half, shouldn't we?
Yes.
Before we do, because that says that there will be many cases in which the absence of any adverse consequences flowing from their serious procedural irregularity will mean that the appeal will fail, but then some cases in which it will succeed. So we do have to bear that in mind when we turn to look at the amendments.
Yes. Well, my lady, this is what I'm saying. The consequence of what followed is also important. Because in effect, if one looks at the proposed amendment, and which was refused, and the case were to be heard, now at that point in time, the appellant would have to swear to speak the truth as a witness. And he would not have been able to go beyond his pleadings, knowing fully well those two very contradictory facts. First, in his defense, he's admitted to the debt, but now he has produced documents, albeit tendered documents, that will be produced in the hearing, which would suggest quite the contrary. Now, that would be a very odd situation for him as a consequence, which means that, one, he cannot go beyond his pleadings, but second, if he were to stay with his pleadings, he would effectively be lying.
Yes, so you've moved on to the consequences that it had for him once the amendment had been refused.
Yes.
But I'm still interested in what the case was that was being put forward in the amended pleading.
Well,
it was clearly very different from the original pleading.
It was indeed very different.
And what, in a few sentences, did it amount to, the amended defence?
Well, it amounted to the fact that the plaintiff was not at all a builder. The plaintiff was a promoter who had sold 2 apartments, and the defendant, the appellant, actually overpaid the plaintiff by 72,000 rupees. And he sets out in his proposed amendment the figures, how he arrives at that figures, and he has documents to support the averments.
What is escaping me at the moment is why he couldn't, from memory, without the documents, have pleaded the different figures. Because at one point in your written case, you are suggesting that there's been an addition of, for each flat, to the contract,
that's
doubling the price.
That's also very, very, very odd, because in
well, can I just
contract,
I
the building
think my lady
contract.
would like to complete her question.
Yes,
finish
sorry.
the question?
Sorry.
If it's right that the price doubled from 1.75 million to 3.5 million, that's something that surely would have been recalled without a document. Now, I haven't quite been able to marry up what you've put in your written case with what's in the amended pleading, but nonetheless, if it's right that it's a suggestion that the price was doubled, that surely would have been memorable.
Yes, I think at this time, when there was the issue of doubling the price, what the appellant initially says that there was the price that is stated in the building contract is not the right price, and the way
I think my lady's point can be put directly like this: your client admitted that he owed the sums.
Yes.
In a number of the pleadings. Now, if in fact he believed that he was paying double, why did he admit that, given that you don't need documents to establish that that is the case? At least one wouldn't have thought so.
Yes. I do not actually have an answer to that, other than saying that the document was translated by his stepson, and because he doesn't speak English. Well, he knew at that time that the building contract, which was a contract between the parties, and the reasons why it was a building contract, we are not getting into that, but he knew that it was not for one apartment at that stage. So he, out of his sheer honesty, he informed the respondent that the price stated therein is for one apartment. Unfortunately, I cannot assist your lordships more on that.
Right, let's move on then.
Well, this more or less, this concludes, my lord, our submission, unless, of course, we can assist the court any.
Do you want to say anything about the arguments that are deployed against you in relation to the settlement of the case? I mean, it is said, and this is a very crude paraphrase, but it's said by the respondent that whatever else may be disputed about the case, you asked that the case be maintained, which I assume means that it be kept in the list. You then took instructions from your client and that you settled the case.
Yes.
And that that is an end of the matter.
Yeah, it is. This is, as I said, my lord, once the proposed amendments were refused,
Yeah.
there were only two options open to the, well, there are three options, to be honest. First is to appeal, ask for leave and appeal,
Yeah.
which was not done.
No.
The second is to go for trial.
Right.
And in that possibility, you will not be able to say exactly what happened
Yeah.
because you're bound by your pleadings.
Right.
And the third was to settle.
Yeah.
And obviously settle and ask for redress. That's the only explanation that I can give, my lords.
Thank you very much.
I am indeed obliged.
Could you just help me on one
Yes.
puzzle? Page 105 in the Court of Appeal, it says no one appears for the appellant, whereas as far as I can see, it's clear that you did appear for the appellant. Is that just a mistake?
Yes, that is well spotted, my lord.
Well, you certainly did appear, didn't you?
Yes.
Seems to be clear from the body that you did. So
Yes. I think probably it is referring to the correspondent, actually.
I see.
I see, yes.
There
All right,
is
well,
a-
anyway, it's not a major point. Good.
Yes.
Thank you.
Thank
I'm
you very
obliged
much.
to your
Thank you, Mr. Trelawney. Ms. Lewis? Now, Mr. Pennington Benton.
My lord, my lady, thank you very much. I think I can take this at a reasonable speed, given where we've got
Sure
to.
you can.
Thank you very much. The first point, as I say, well, look, the appellant did have a fair opportunity to make his submissions. These are headline points, I'm going to flesh them out, but he had a fair opportunity.
Are you maintaining the point that he didn't get leave and should have done at the first court?
Yes, the Court of Appeal should have dismissed the appeal outright, just on the fact that
But having heard it,
Yes.
can't they be taken as having implicitly granted leave?
I can see the logic in that.
Probably not your strongest point.
Probably not my strongest point. The next one's really good. He did have a fair opportunity, and I'm going to take to Court of Appeal, English Court of Appeal decision on that. In any event, there's no injustice here because full argument was had on the amendments before the Court of Appeal. All the relevant authorities that are put before your lordship were put before the Court of Appeal. The Court of Appeal effectively sat and remade a decision, and effectively for the same reasons as the judge said, well, it's all too late. Sorry. There's no justification in my submission for this court to intervene on a second appeal. And thirdly, the appellant did not appeal the case management decision. The real decision at issue here was the refusal of the amendment. Now, if the appellant had sought to appeal that decision, he would have needed leave of the trial judge. So that's what the Court of Appeal Act says. But what he does instead is appeals the final judgment. And in my respectful submission, even if something went wrong with the case management decision, there's no necessary link between that and the final judgment. The final judgment is a separate issue that was given by consent. There was an unequivocal agreement between the parties presented to the court. The judgment was given. As to the first point, I just rely on the case of LaBrouche. It goes against me as much as it does for me. I mean, I put it in there because I think it nicely fleshes out the issue. But I'm afraid I've not got my head around the facts of the case. It's some sort of terribly complicated trust case. But in the end, basically...
Much too busy, Mr.
Sorry?
You're much too busy to get your...
Well, I didn't want to perhaps distract myself by trying to understand the underlying facts of this case rather than the central point.
I don't want you to distract yourself.
But the strikeout application, this is at paragraph 10, came on before the judge with a time estimate in itself of 3 days.
Yes.
And then Mr. Justice Peter Smith, this is at paragraph 12, comes out and says, second sentence, I'm firmly of the view that an argument on these papers that the proceedings should be struck out as being an abuse is really beyond the reach of sustained argument.
Yes.
Further down, what I am proposing to do is allow the action to proceed, set the timetable for the trial date, preserve proper evidence, the right of the defence to argue in a estoppel point. That is what I think should happen. Pause. Now, there's a broad analogy between that and effectively what happened in this case, which is the trial judge came out and said, well, look, this is a very late amendment. It's effectively made on the day of the trial. Understandably, he took a rather robust view to it. I'm not going to allow it. And at that point, my learned friend, with respect, had the opportunity to do what Mr. Newman did in this case, which is to say, well, 2 options. One is I could stand here for a day and seek to persuade your lordship that your lordship is wrong in your lordship's initial view. The other option is I appeal. And that, in my respectful submission, is what should have happened in this case. The appellant should have effectively stood his ground and said, well, look, I can see why your lordship might come to that provisional view. It's all rather late in the day. However, I'd like to say something about that. I think we've all probably found ourselves in that position as advocates, and sometimes that's what's required. And actually, Lord Neuberger does make that point.
Well, Mr. Trelochan in this case says that irrespective of what his stance should have been, the court itself was under an obligation to examine the reasons that the amendment was sought. And by denying itself that opportunity, it fell into error, and also, incidentally, in breach of Rule 17.
Well, I'd respectfully submit that experienced commercial trial judge is bound to have known what the test is for these amendments, and is bound to know, which comes out in the authorities that relied upon by my learned friend, that undue delay is one of the good reasons to knock an application like that on the head. I mean, the fact that the judge did it quickly is just a reflection of a robust view that he took on the merits. There's no suggestion there that he hasn't understood what's been said or hasn't understood the nature of the amendments. And I should say, in that regard, a submission of my learned friend to the effect that the judge didn't read the amendments was specifically, the proposed amendments, was expressly rejected by the Court of Appeal.
Where was that?
Which, it's at volume 1, tab 1, page 110. Line 10, 11, 12.
There's nothing in the record to
Yes.
suggest that the learned judge has ignored the contents of the proposed amendment, and that the appellant had a good defence and a valid counterclaim.
That was one of the clear allegations made, that the judge had ignored all this stuff. There was nothing supporting that. But really,
Yeah, I mean, there's no suggestion that you had the 5 hours that Mr. Justice Peter Smith took, but then
no.
it was a rather different case.
Yes, a 3-day strikeout application. But obviously these things are fact sensitive, and I have put in the Dunbar case because, in fairness to my learned friend in the Dunbar case, the judge there gave an extemporary judgment, and there was no suggestion that anyone should have stopped him from giving the extemporary judgment and intervened. But every case, obviously, is fact sensitive. But in this case, as the Court of Appeal rightly found in my submission, there was an opportunity. There's no indication that the appellant's counsel was going to make further submissions, and there was no attempt to make those further submissions. And just returning to the judgment, but the second point is that in any event, all of these arguments were made in the Court of Appeal. So in effect, the appellant's had his day in court on this issue. And there's nothing to suggest that the Court of Appeal went wrong in principle, such that this court should intervene. Just finishing off the judgment of Lord Neuberger in La Bruche, paragraph 29 is important. Mr. Torbay, I'm not sure, one of the counsel, quite rightly said that it is the duty of an advocate to stand up to a judge who is proposing to take an inappropriate course, such as refusing to hear argument. It was also right to suggest that if a judge states that he's proposing to take a certain course, and a party's advocate does not object to that course, an appeal by that party based on the proposition that the judge ought not to have taken that course, in the absence of special factors, be doomed to failure. However, where a judge makes it clear that he is resolved on taking a certain course and there is no prospect of a party's advocate being able to dissuade him from that course, it's hard to see what else the advocate could do. We're simply not in that territory. There's no evidence that that effort was made and that the judges, I accept he made a decision, but that decisions that are made, one-line decisions that are made like that can very easily be turned into preliminary views and further argument had. That's the point. The second point, just to give your lordship some references to the fact that this argument was vented. The point about the amendment was vented. Volume 1, tab 2, page 83, so it's the same as the memory stick number. That's the appellant's skeleton argument before the Court of Appeal. What we see there, page 85 in particular, is reference to all of the cases that are here before your lordship. In particular, passage from Lord Griffith's judgment in Ketman, whether an amendment should be granted is matter for discretion of the trial judge. A judge is entitled to weigh in the balance the strain and litigation imposed on litigants. Further down, another factor the judge must weigh in the balance is the pressure on the courts caused by the great increase in litigation, consequent necessity that legal business should be conducted efficiently. So, and then there are obviously extensive submissions during the hearing of the Court of Appeal itself. Page 93 of the record, this is my learned friend, at line 34 and following, is there especially mentioning Rule 17 and then going to the authorities. There's extensive argument on all of that. And then there's a response from Mr. Deming. And there's an intervention at page 96 of the record, 35, line 35 on that page. My lords, the next point is that the learned judge failed to consider that the appellant, then defendant, had given advance notice, as I already pointed out. Court intervenes, yes, but on the preceding Thursday for a case coming on Monday. I mean, that's the issue in this appeal. And then, as I say, Mr. Deming responds. So once we then get to the Court of Appeal judgment, it's dealt with quite shortly, I accept, but there's no suggestion, and can be no suggestion, that the court did bear in mind all of these submissions and bear in mind the authorities that are relied upon today. What the Court of Appeal says at page 110 of the record, line 3, we agree with learned counsel for the respondent that the learned judge made a judicial exercise of his discretion and rightly refused the belated motion for amendment made on the day of the trial. Observed that the amendment had been made 2 years earlier and so on and so forth. Next paragraph down. There was no refusal to merely refusal to amend the plea on the very day of the trial, a discretion exercised by the learned judge in accordance with his assessment of the requirements of justice so to ensure a fair trial within a reasonable time. Well, that's the overriding objective. That reflects the authorities that my learned friend refers to, and therefore the appellant, as it were, has had his argument and he's had his day in court, whatever. Thirdly, the very last point, which is a one-sentencer, is that there has been no appeal against the interlocutory order. Insofar as the judge refusing the amendment was an interlocutory order, there's been no appeal against that. Effectively, what the appellant says is that because in theory something might have gone wrong with the case management decision, I can't be held to the consent I gave to judgment. My respectful submission, that doesn't work. There's no indication of any caveat or condition being entered before the judge, and therefore the two issues can be treated separately.
Yes. Thank you very much.
Thank you.
Mr. Trelawney?
Very briefly, Lord. On the issue of whether it was a case of case management, if I refer you to your Lordship to La Bruche again,
Yes.
and paragraph 43, that is tab
Yes.
I. This is the last page of the judgment, my lords. And if I may read, it says, however, even assuming that the decision in this case was a case management or procedural decision, it was simply unsustainable. It is fundamentally wrong for a judge to refuse to hear oral judgment on behalf of a party whom the judge has decided to find against on reading the papers. I do admit that here there is no expressly, it hasn't been said that he's refused to hear argument. Coming back to what I said earlier, that there was no opportunity given. But perhaps another point that I would like to apply is if I take your lordships to volume 1, which is the record, page 110, which my learned friend has referred to. It's the second paragraph. First point, my lord, is that the Court of Civil Appeal seems to suggest that there's nothing on record that the learned judge has ignored the contents of the proposed amendments, but there's nothing to suggest that he did.
But it's not incumbent on you to establish that he ignored it.
I can only go by what's on the court record. And when one looks at the court record, the way it's said, there is nothing to suggest that he had, or he hadn't.
Can you just help me on that? I see at page 108 there's a reference to a judgment in Ramden and Go Paradise, and section 23.
Yes, this basically establishes that whatever is on the record is correct.
Well, you can't produce evidence to show it.
No.
Falsely stated.
No. And yes, I hope I answered the question, my lord, on that issue. But more importantly, if one looks at that particular paragraph at page 110, the Court of Appeal seems to say, secondly, you agree with learned counsel for the respondent that, in fact, the learned judge made a judicious exercise of his discretion and rightly refused a belated motion for amendment. Now, with all due respect, my lords, what was the judicious exercise? This is the finding of the Court of Civil Appeal. But the judicious exercise, one can only come to a conclusion if one looks at the proposed amendment, if one hears whether it actually will determine the question in controversy between the parties. None of that was done. Everything happened in 2 minutes. So what was the judicious exercise that the Court of Appeal is referring to here? I think, my lords, that would be more or less the reply, unless I can assist your lordships any further.
Thank you very much, Mr. Trelawney. Very nice to see you again. Thank you.
The pleasure is shared.
Thank you.
I'm obliged, my lords.
Well, we're very grateful to Council, not only for their very helpful submissions, but also for the economical presentation. The Board will take time to consider a judgment, and it will be promulgated in due course. The Court is now adjourned.